All right. Hello, everybody. Welcome. It's our September 23rd live stream every Wednesday at noon. My name is Brad Chaplick, and I am a condominium lawyer at Horlick, Levitt, Lella. So this is our, 26th or 27th version of this live stream, and we're still going strong, and we thank you all for joining us today. Lots going on in condo land in response to a recent spike in COVID cases across Ontario. The provincial government has announced new restrictions on social gatherings, but has exempted certain businesses from these restrictions because I guess the idea is you want to not clamp down on the economy again, but you still want to control the amount of unmonitored social interaction, house parties, that kind of thing. But as always, no one stops to think about the effect on condominium corporations and whether condominium corporations are a quote business or organization that is exempt from these lower gathering limits. I don't think that a condo is exempt. So if you have not yet subscribed, you can click the button below and subscribe to our channel and click the notification button and be advised of future videos. We've got a video coming out soon about a recent case, the Fraser case. I don't want to spoil it, but it has to do with condo policies during COVID and what condominium corporations can and can't do and whether the policies will be upheld by the courts. Excellent case. Much needed precedent setting decision in this new area of law. So, because the first question from Olivia is on point with the new issues that we're facing, I'll jump to that question first. And for all the other viewers, please type your questions into the chat and put in as many questions as you think you need the answer to so that we can give you the most information during this session that we like to do. So question from Olivia. Hi Brad, with the new restrictions as of September 19th regarding indoor gatherings, 10 people per room, does this apply to AGMs held in condo buildings? How about if the AGM is held in a banquet hall? Well, Olivia, you are like right on top of this. You've identified the exact issue that is facing condominium corporations, and we talk about this in the FAQ that we distributed yesterday. So in that FAQ, and I'll explain again now, in my view, condominium corporations should assume that for their indoor amenities, you are in fact limited to 10 people. So 10 people per room if you're thinking about a party room. So if you were planning to have your annual general meeting in person in the party room with 50 people, that's not happening. You're going to have to move to a different location, or you're going to have to change your meeting to be virtual or hold it with 10 people, which is really not feasible for any decently sized condominium corporation because, once you add the board of directors, management, and your meeting professionals, you're at 10 and there's no owners present, and that's not much of a meeting. So I think you're limited to 10 people. Now let's talk about the banquet halls. The banquet halls are exempted. For them, the limit is 50 with physical distance of 2 meters between each person in attendance they're not of the same household. So if family members don't have to keep 2 meters distance from each other. So if you were planning to have it at a banquet hall, you could probably continue with that plan. But I think you should still think about whether it's a good idea. Because just because something is technically legal doesn't mean it's the right thing to do. And I think for those condominium corporations that are planning to hold in-person AGMs this fall, they should really be thinking hard about whether that's the smartest and best thing to do. Even if it's in a banquet hall with 50 people, is that really responsible, and is it, for example, inconsistent with other policies that the condominium corporation is trying to implement within the building, encouraging people to maintain distance and act cautiously, because you don't want to have a COVID outbreak in your building. It's distressing to your residents, so and unsafe. So for that reason, I think that if you were a condo planning to hold an in-person AGM, you might well want to reconsider and go electronic. And if you're determined to go ahead in person, then you better make sure that you've got systems in place to keep everyone safe. And I think that would include, at a minimum, a health screening questionnaire, and making sure that people are physically distant and wearing masks during the meeting. All of these things. So, yeah, so that's the answer about the rules and meetings. So while we wait for some more questions to come in, I will just turn to some of my notes and talk about some of the other aspects of the new rules. So something that we're expecting to come in, but I don't think it's been legislated quite yet, is that the fine for breaching these new rules, the 10-person indoors, 25 people outdoors social gathering, the fine is $10,000 being proposed for the host or organizer of the gathering. If you're talking about a condominium corporation's common elements, that could very well include the condo or even the property manager. So I think the condos have a bit of exposure. And I'm not saying that the financial exposure is going to be your main motivation. I think safety is your main motivation, but there is a secondary issue there of financial risk if you don't implement these rules and monitor your common areas. And also that these rules were expected to remain in place for at least 4 weeks. So that will take us to very close to the mid-October or October 22nd deadline for a lot of condos to hold their AGMs. So Harland has a question. Outdoor is limited to 25 people, although it's prudent to wear a face covering. Is it mandatory to wear coverings outdoors? No, there is no. So the question is, do I have to wear face coverings in outdoor social gatherings? And the answer is no, you do not. You might want to if you're in a group of 25 people, and I think it would be a smart thing to do, but it is not required by law. The face mask bylaws, which are municipal and include York Region and City of Toronto and Peel and a bunch of other places, are only for indoors. So you would not necessarily get a ticket or anything like that if you had a face mask outdoors. Now, if the condo was going to organize a meeting, I think it would be smart to say that for anyone in attendance, you want to, even though it's outdoors, you'd want them to submit a health screening questionnaire and wear a mask, but not required by law. So this brings me to another point, which Harland is alluding to, which is, can condominium corporations have their own rules or policies that are more restrictive than provincial emergency orders, or in this case, a municipal mask bylaw? And the answer is yes, because condominium corporations have a duty to provide an environment for residents and staff that is safe and free from hazards. And because of that, you have the discretion as a condominium board to implement policies on an emergency and temporary basis that are more restrictive than these government bodies. And that's what the Fraser case is all about, and why it's such an important case. So you do have discretion to be more strict, and many condominium corporations have done so, and I think have done so quite prudently. So, will the government extend the virtual meetings exception, or do we still need to pass a bylaw before the November 21st deadline? Well, this is a really great question, Will. We don't know the answer. All that we know, so it's, okay, and then there's a related question from Brian, which I'll answer as well. All we know is that we got an email from the ministry that said that there were two issues. Issue one was, would they extend the deadline for holding the AGM, and they said they would not extend the deadline for holding an AGM. So that answers Brian's question, which is, so all those deadlines in the table that you'll find in our email blasts, those deadlines are hard deadlines to hold your AGM. Now, some condos might miss them by a few days, and you just do the best you can. But those deadlines are not being extended. But will the exception for virtual meetings be extended? They suggested that they might. And to me, you would only say that if you intended to do it. But they haven't done it yet. So I think it's likely that the virtual meeting exemption will get extended past November 21st. I don't know when that announcement will be made. We are booking virtual meetings past November 21st just because of the timing of condos and when they need to have their meetings and what their availability is. So we are booking meetings into like later in November and into December. And we are hoping that by the time those meetings are held, the deadline extension will have been passed. But if it's not, then you may find that condos are scrambling to pass last minute bylaws, and that we have a plan for condos to do so. And the plan is basically to do it by way of a paper meeting. So it would just be proxies only, no attendance, and you would collect enough proxies for quorum, and then you would use those proxies to vote the bylaw in, and then that would allow you to then go ahead with your AGM and have owners participate in a virtual meeting. So we hope we don't have to do that sort of last-ditch scramble for a paper meeting, but the option is out there. But we don't recommend that you do your AGM by a paper meeting, because of course owners have the right to participate in the AGM, including maybe hearing a speech from the candidates for election for director, or asking questions of the auditor, or raising other business. So for all those reasons, a paper AGM is not a good idea, but a paper meeting to pass a bylaw to allow you to have a virtual AGM is an entirely different matter, and generally speaking, much more acceptable. So, and it was previously sort of approved by the CAO, the Condominium Authority. The idea of having these paper meetings to pass these bylaws was actually first, I don't know if it was first suggested by them, but it was put on their website as a viable option back in the summer. So with all that in mind, I think it's probably okay to do. So let's see if there's new questions here. From Harland, if an owner organized a get-together, can it be stopped if there is no medical screening done? I'm more concerned, Harland, with social gatherings that are organized by the condominium corporation, and that when the condo is the meeting organizer, that in those circumstances, the condominium corporation takes steps to ensure that anyone who attends in person has answered that they are symptom-free of COVID. If unit owners are going to do their own social gatherings, 10 people in their unit or 25 people outdoors, those types of gatherings, I think you would just want to make it clear that the condominium corporation is not sanctioning them, and you would probably want to write to the person organizing it saying, we want you to ensure that the people attending do not have symptoms, or they shouldn't be there. But I don't think you wouldn't want to stop it. You would just want to make your position clear to the owner who's doing the meeting. I guess it sort of depends where it is too. I mean, you might decide, for example, if you have a party room and someone wants to reserve it for a 10-person social gathering, you might say, as a condition of your reservation of our party room, you have to use this questionnaire and track and give us the names of everyone in attendance for contact tracing purposes. I think that would be pretty standard and reasonable. So, you just want to use your best judgment and tailor something to your specific situation. So, hard to answer in the general for every possible situation, but I think I gave you a few ideas as to what would be considered acceptable. But it's tricky stuff, tricky stuff. I would say if you're not sure, side with caution, right, in terms of what you're going to allow owners to do, where it's sort of a tipping point moment in terms of the health and safety of our population. So WC asks, hi Brad, how does the corporation enforce a code of ethics? Does the corporation require certain bylaws to enforce a code of ethics among board members? It can be done by bylaw, and quite famously, that's how it has been done in the past. So just to sort of inform those who might not know what we're talking about, some condominium corporations have a director's code of ethics. I'm assuming you're talking about a director's code of ethics. Yes, as amongst board members. Okay, so it's a director's code of ethics, and it might say things like you can't defame other directors. You have to, go about your business in a professional and courteous manner. You can't disclose confidential information. These types of things. So the way you would enforce such a code of ethics is you would have in your bylaws a qualification for directors, and the qualification would say that every director must sign the code of ethics, and that if a director breaches the code of ethics, and you have a process for determining whether it's been breached, then that director might be disqualified from the board, and that's how it's enforced. So I hope that answers your question. But yeah, you do it by a special bylaw and by amending your director qualifications. And these types of bylaws have been challenged up to the Court of Appeal and upheld as proper and reasonable. So there you go. That's how you do it. Will, thank you, Brad. Regardless of an extension by the province, having a bylaw is probably a good idea anyways, given this pandemic will last for a while. So this is Will's talking again about the November 21st deadline for virtual meetings and whether people should have electronic meeting bylaws. And I think I would agree with you, Will, that it is to every condominium corporation's benefit to have one of these bylaws. We do not know how long in-person meetings will be recommended, and even looking into the future, you might expect that people's habits will change and that it will no longer be considered like normal to go to a condo meeting with 300 people. People just won't want to do it anymore. They'll appreciate the convenience of being able to vote on their tablet or their laptop or their cell phone, and to watch the meeting with one ear while watching Netflix in their pajamas with the other eye and ear. And people just might find that that's really a better way to do it, and it's more convenient, and that there is no need for everyone to sit there in person for 3 hours when maybe you're only interested in part of the meeting, but it would be rude to stop paying attention or to get up and leave halfway through, right? So I think electronic meetings are probably here to stay, and condos should adapt. I think it's going to be something that people expect, just based on my own practice, right? Like I don't think I'll continue having people come into my office in person if I can do Zoom meetings. I think that I would say that it's more convenient for everyone just to meet on Zoom, and then people don't need to drive and park and do all these things, right? So it's probably what's going to happen. All right, Shelley. Hey, Shelley. Our individual condo fees include utilities, gas, water, hydro. Working from home during COVID has increased utilities costs. Is anyone lobbying the government to help us pay these extra costs, to help condos pay? No. I mean, there have been steps taken to reduce utility prices, right? There's energy rebates, and I think the government also, at least for part of the time, the government also had a plan where daytime electricity was being billed at the same rate as like off-peak. So there have been some steps taken to try and reduce those costs. I'm not sure if the off-peak electricity is still in effect or if that stopped, but that's it. I think that's all you're going to get is the tax rebate and then the fact that the off-peak pricing. So other than that, I think you're on your own to pay these extra costs. And I think if you're a condominium corporation and you see the bills and you know that you're going to be short, you want to signal that to owners in advance and let people know that this is something that's coming and that there might be, if you think it's like a one-time bump, you might do it by special assessment rather than by raising people's maintenance fees because you think it's going to go down again in the future, and so you don't want to like have to raise the budget just for this. You just want to say, okay, we had a one-time utility surge of whatever, $50,000, so we're just going to pay that off and then keep the maintenance fees the same. And I think people would be understanding if you have signaled to them in the lead up that this is coming. So it's a sort of a political way of dealing with the problem, but not a solution, I mean, in terms of getting an actual rebate. WC, for board meetings, if some members prefer virtual and others prefer in person, is management required to accommodate both, say as a hybrid? So right now, there is an exemption from the requirement for unanimous consent to hold board meetings virtually. So right now, you can hold a board meeting virtually even if one director opposes it. Now, that is something that will also need to be extended because it's set to expire November 21st. After November 21st, assuming that there's no extension, the law will be unanimous consent is required for owners to participate in, or sorry, for directors to participate in board meetings by telephone or by video conference. So I would say the consent issue aside, if a director wishes to attend the board meeting by telephone and, leading up till November 21st, I would say that they should be accommodated, and it's really not difficult, right? You have them on speakerphone, so there's not much more to it than that. But if you have multiple people, then I think you would do the meeting on Zoom, and you would just have all the people who prefer to be in person in the same room on one camera, and then all the other people who are there individually on their own camera. And so the meeting is essentially taking place as a virtual meeting, but some of the people just happen to be in the same room. Anyways, that's the way I would do it, and I hope that answers your question. So yeah. Jerry, thank you, Olivia and Brad, regarding the question concerning the new limit. Oh, yeah, thanks, Jerry. Appreciate it. So let's talk about some of the other issues here. So, do we have meeting dates available? We get this question a lot. Yes, we have meeting dates available. We have dates up until really recently. I think we even had dates in October, but we have dates in November. We have dates in December. And if you are still thinking about booking your AGM, then let us know, and we'll give you dates. And then questions about electronic meeting bylaws. Yes. Okay. So let's talk about how a virtual AGM works. Because if you haven't seen one, you might be wondering, like, what does it look like and how do we do it? And the answer is it's actually not that different from a regular AGM. There's almost a comparable substitute for each of the different steps of your meeting. So the first thing you do when you have your annual general meeting is you do your preliminary notice, your 35-day notice, sometimes also considered like a call for candidates, and you send that out. So now you would send that out just as you always would, and it would just have a little bit different information in it, letting people know that the meeting will be held virtually and that you'll need their email address if you don't already have it. Okay, great. So you send out your preliminary notice of meeting, and the best practice I would say is to get your lawyer to check it and make sure that all of the information that you need is in there. Assuming that you're going with HLD meetings. We'll check it for you, and then you've got your preliminary notice package. Manager sends out the notice package just like always. Great. You get your candidates, all your people who want to be on the board, and that's just the same as always. And then you collect your email addresses and you put them in a spreadsheet and send them to the meeting host. And that's going to be true of any person who's hosting your meeting. Any service you use, they're going to require you to give a list of email addresses. Okay, great. So that's the next thing you do, email addresses. Then you do your notice of meeting package. Again, just like always, you're doing your manager puts together the package. In this case, you're going to put it together in draft a few days before you actually need to mail it out. You're going to send it to us. We're going to review it. We're going to make sure all the correct information is in there, probably change your cover letter a little bit, make sure your proxy makes sense, all that stuff, and then send it back to you. And then, you, just as always, print it out, stuff the envelopes, or email it, and out it goes. And so that's all the same, or very close to the same. And then the next step is registration. So in a normal meeting, you do the registration 20 minutes before the meeting starts, or half an hour, and everyone lines up. But this time, because it's electronic, we do it by email. So all the owners will get an email from HLD meetings, and they will have a link, and they'll click the link, and they'll register. And by registering, then they'll get another email once they're approved to enter, and their credentials match, which is the link to enter the Zoom webinar. The other thing is proxies. So proxies will still be delivered to the manager, except this time you'll have a deadline for submission of proxies because they have to be compiled and reviewed in advance of the virtual meeting. So you can't have people show up to the meeting with paper proxies in their hands because there's nowhere to show up to, right? They have to be submitted somewhere in advance. So management office, either by email or dropping them off. So we'll get all the proxies, at least a day, preferably 2 days before the meeting. And then we've got everyone registered electronically. They get their link. And then, clicking the link and entering the Zoom webinar is just like walking through the door of a regular meeting room. And so once we're in the webinar, you have panelists and attendees. The unit owners are attendees. They can see the panelists. They cannot see each other. So the unit owners are not on camera. The only people on camera are the board of directors and the chairperson and anyone else who you have on the panel. So that's why it's a webinar. It's not a Zoom meeting where everyone can see everyone. It's like when you sign up for a training course or something on Zoom. It's like that. So during the meeting, one of the meeting hosts will share his or her screen, and that will have a slideshow taking you through the meeting agenda. And so then all the owners will be able to see the panelists speaking on camera, and they'll also be able to see the slideshow following along. And then you do your motions. People can raise their hand to speak and ask questions. They can type questions in, and they can vote on polls for passing motions. So like to approve the minutes and stuff, like just a little click box will pop up on the screen. Click yes or no, and then the results pop up instantaneously. And then you also have electronic voting. So for sealed ballots for the election of directors and passing bylaws, the people who have not submitted proxies get an email. The email has an electronic ballot. Click it, open it up, vote just like a survey box, vote yes or no in favor or against which director you're voting for, and hit submit. We get the results instantly. We combine it with the results on the proxies, which have been counted in advance, and then we announce the results. So it's actually usually quite a bit faster than a in-person meeting, just because all the counting takes place in advance and electronically. and most people really are quite satisfied with it. So that's how the electronic meetings work. And if you were wondering, and we're still working out the bugs. Every meeting presents some sort of new challenge, but they're getting fewer and far between. And I think we're starting to really get the hang of it, having done a whole bunch of them. And I'll be doing one tomorrow. And after that, and after that, and after that, we've got all lined up through October and November. So we're going to do like hundreds of meetings, and it's a big thing. Never thought we would be a software company, but here we are. And then after this 2020 crunch is over, then things will normalize a little bit, and we'll be able to provide a lot of meeting dates and options for people who are still wanting to do their 2021 EGM, but they'll be more spread out and hopefully a little less hectic for our staff. So that's me. We've been going for half an hour here. Haven't had any questions pop up for about 5 minutes. If we got no more questions, we've got no more questions. But if people have more questions, I'll keep answering them. I'll also just mention, by way of reminder, we talked about this a couple weeks ago, in the city of Toronto, short-term rental registration is open now. It opened on September 10th. Short-term rental operators have until December 31st to register. After that, you're breaching the bylaw, you're going to get ticketed, you're going to get shut down. So managers will be able to call 311 and report prohibited short-term rentals. So that's going on with the City of Toronto. And October 1, expanded Condominium Authority Tribunal jurisdiction, most notably to include pet disputes. So look for a sort of surge in cat cases come October 1, and cat as in Condominium Authority Tribunal, not as in felines, but cats as in felines too. So there you go. So that's what's new in condo law, and I hope that you're all staying up to date and safe. And if you think of more questions after this session is over, send me an email, bchaplick@hldlawyers.com, and we'll get you an urgent reply. And thanks everybody for attending yet again. And like I said, we'll keep doing this as long as there's a need and as long as there's an interest. And I'm not sure if going into 2021 we'll do it every week, but we'll keep doing them as we need them. Oh, last little question here. Registration to virtual AGM. Could two owners, owner and co-owner from the same household, register for the virtual AGM, assuming co-owners have provided electronic consent email addresses? So yeah. More than one owner can register, but they would not receive 2 ballots. So they would only get one email with the voting, and but you can have 2 owners present representing 1 unit. And we do check when people register that they are which unit they're representing. So that way we have accurate counts for quorum and things like that. So yeah, multiple owners can register. The most common thing by far, though, is that you'll have, if it's people from the same household especially, is that they'll just register together as one person, but you can tell when they speak that there's actually 2 people there. The owner, the co-owners are both there, husband and wife or whatever. And so that's the most common way that it's done. Co-owners don't usually register separately, but they can if they want to. For example, if they're in different places and they want to both be able to speak and address the meeting. So totally fine, and we can accommodate that. Yeah. All right, everyone. Thank you so much. It's been a pleasure, and we'll see. Brian will see you next week, and I'll see you the week after that. Take care.